The Supreme Court criminal docket often is a chance to make incremental changes in the way that criminal procedure operates in the country, and we have a number of colorful cases this year, especially compared to some of the other aspects of the docket, and some wonderful experts to discuss them. We'll introduce each of the folks as they come up, but we hope to have about 10 minutes for each of our speakers here, and then some discussion with the rest of you. And at the conclusion of each of our speakers' remarks, if you have a really interesting or urgent observation or question, let's hear it then. If it's something that is just to earn points with a teacher or something, hold that till the general question period at the end of our panel. First off, I mean, there's nothing that steals the scene like a dog, as W.C. Fields told us. And stealing the Fourth Amendment scene for us this year are two cases involving dog sniffs. And dog sniffs are obviously not a treat. They're describes a police investigation method to discover contraband. And to talk about the two cases, which have somewhat different procedural significance and different significance for what types of Fourth Amendment inquiries they trigger, is our friend Erwin Chemerinsky, who's here all the way from Irvine, California. Just a personal note: when I started out in the news business, one of the things, a very sad thing I had to do early on, was write an obituary for a police dog, Baron von Brausfels of the Newport Beach Police Department, who unfortunately died about a week after arriving. And it was a very sad occasion for his trainer and for all of us in Orange County. So we know that police dogs are an important part of the Orange County lifestyle. And to talk about the two cases we have here is Dean Chemerinsky.
I do get to talk about Frankie and Aldo. The first case that I'm going to talk about is Florida versus Jardin, and that involves a black lab by the name of Aldo. The police got a tip from crime watchers, just an anonymous tip, that there was a marijuana growing operation going on in the house. Sometime later, a police detective, accompanied by a police dog and the dog's handler, went to the front door of the house, and the dog gave whatever signal dogs do when they detect the presence of drugs. And on the basis of that dog sniff, the police then went and got a warrant to search the house. They did do the search, and the police found a substantial amount of marijuana. And the issue here is, was the dog sniff itself a search that required a warrant? Or was it permissible for the police and the dog to go sniff from the front porch without needing a warrant before doing that? Now, what's interesting is there's no Supreme Court case on point, and what the Supreme Court does may very well depend on what analytical framework it wants to use, what precedents it wants to apply. There have been two prior Supreme Court cases dealing with dog sniffs, neither exactly on point for the situation. One was a case called United States versus Place in 1983. It involved a situation where the police used a dog to sniff luggage in an airport, and the Supreme Court found that that didn't violate the Fourth Amendment. The court recognized that people have a privacy interest in the contents of their luggage, but the Supreme Court noted that here, the police weren't opening the luggage, nobody humiliated by seeing what's inside the luggage, that it was just sniffing the outside. The luggage was, after all, in a public place within an airport. The other is a case called City of Indianapolis versus Edmond, 2000. What was involved here was Indiana set up checkpoints to stop cars so as to see whether or not the cars were carrying drugs or whether the cars were carrying other easily recognizable contraband. When the cars were stopped at the checkpoint, a dog was there to sniff the cars to detect drugs. The Supreme Court declared these checkpoints unconstitutional. The Supreme Court had earlier said sobriety checkpoints are permissible. The court distinguished that by saying sobriety checkpoints exist for the purpose of getting intoxicated drivers off the road. This is a checkpoint that exists solely for the purpose of stopping drivers to see whether or not they've committed a crime. The court said that's not permissible. But the court didn't find the drug-sniffing dogs particularly objectionable. The court noted that the car was in a public place to have a drug-sniffing dog go around the car didn't bother the court. Now, the other case that I think is quite relevant here doesn't involve dogs at all, but it involves homes. It's a case called Kylo versus United States from about a decade ago. In this instance, police used a thermal imaging device to see whether or not there was substantial heat coming from a house that would indicate the presence of a marijuana growing operation. Marijuana growing uses a great deal of energy, and so they thought by taking a thermal image photograph, they could see whether there was so much energy there that would indicate the presence of marijuana growing. And in fact, you can look on the web and you can see the photograph taken. It looks like a house with a light on in the attic. The light in the attic is the heat coming from the attic from the energy used. The Supreme Court, in an opinion by Justice Scalia, found that the use of the thermal imaging device itself was a search within the meaning of the Fourth Amendment. So the police would need a warrant in order to use the thermal imaging device. Justice Scalia's opinion talked about the special nature of the home within the meaning of the Fourth Amendment. It's mentioned in the text of the Fourth Amendment. Justice Scalia also expressed concern about as technology advances, how through thermal imaging we can see the outlines of bodies. We can see what bodies are doing. We can observe them in intimate activities. Now, if the court focuses on just this is drug-sniffing dogs, the court may say, well, drug-sniffing dogs is just using senses. Police can use their own senses, plain smell when they come to home, so they can use dogs. On the other hand, if the court really focuses on the home as a special place, Kylo, then is there a difference between a thermal imaging device and a drug-sniffing dog? The Florida Supreme Court found that the drug-sniffing dog is a search and required a warrant, and that's what's before the U.S. Supreme Court. The other case with regard to dogs, the one that involves Aldo, is Florida versus Harris, and it's a quite different Fourth Amendment issue. Here was involved was an individual was stopped by the police for having an expired license plate. The police observed the individual and said that he appeared shaky, nervous. Based on their training observation, they thought his signs indicated perhaps he was a drug user. They had a drug-sniffing dog. It sniffed the door handle. Again, the dog gave the signal that dogs do when they detect the presence of drugs. And the police then, on the basis of what the drug-sniffing dog indicated, did a search of the vehicle. They found all of the things that go into making methamphetamines, the underlying drugs, matches, chemicals, and the like. So the issue in this case is quite different than Jardin. The issue in this case goes to whether or not the signal from the drug-sniffing dog was sufficient for probable cause to be able to search the vehicle. And the Florida Supreme Court here said we've given almost mythic reliability to drug-sniffing dogs. And that was the phrase of Justice Parenti on the Florida Supreme Court. And she said, dogs aren't subject to cross-examination. She said, as a result, we really need the police to be able to make a showing of the reliability of the dog in order to be able to use the evidence that's gained on the basis of it. And the burdens that she articulated, quite onerous. So they have to present all records and evidence with regard to the reliability of the dog. So the trial court is able to evaluate that reliability. There has to be training records and certification in terms of how the dog has behaved in the past. How often has this dog given false alarms? The whole record with regard to the dog, with regard to dog sniffing and reliability, has to be shown to the trial court in order for this to be sufficient for probable cause. On the one hand, I think what she says makes great sense, that dogs aren't inherently reliable. There are problems with training of dogs. There's problems with the way handlers can give signals. On the other hand, it's hard for me to imagine that the Supreme Court is going to say that any time the police want to use a drug-sniffing dog as a basis for a search, they have to meet all of these requirements, which really are quite onerous. Now, I've often heard law clerks and others refer to the cases that are least interesting in the term as the dogs of the term. I don't think that's true with regard to these two cases.
Touche. Well, thanks, Erwin. So, moving on from the dog cases, perhaps it's said in the narcotics large trade, that he who deals drugs and walks away lives to deal drugs another day, but that was not the case in U.S. versus Bailey, which is the next topic that Lyle Denniston, the premier correspondent at SCOTUS Blog, and one of my esteemed predecessors as a Wall Street Journal correspondent, will handle for us next.
Okay. Thank you very much. Let me digress a minute without embarrassing them. You should know that in our audience are 3 members of the staff of the Public Information Office of the court, without whose services none of us reporters would be able to do a damn thing. You know, so, could I ask each of them to stand up? And I'm here to talk about, I told them they were Murderers Row, and they thought I was insulting them, because none of them, I think, is a baseball fan and would identify the great row of very heavy hitters that were on the team of the New York Yankees in the 20s. But they're very, very important to me and to Jess and the others who work at the court. I'm going to talk about 3 cases, 2, one in less compass than the first one, Bailey against U.S., which is on page 393 of your prep book. This is not really a case about preppy sports coats and slacks, but there is a person involved named Polo, not Ralph Lauren. Polo was a snitch along the little town of Wyandanch, Long Island. And Polo identified a house on Lake Drive as a place where drug activity was going on. The police obtained a warrant to search this house on Lake Drive. They went to the place. They drove up outside the apartment building, and they did not want to alert anybody that they were there. They were monitoring the scene. And 2 men came out and got into a Lexus. One of the nice things about Preview is that all kinds of dealers in commercial products get free advertising. They came out and they drove off in a Lexus, and they went some distance away. And then the cops flagged them down, because the cops were pretty much persuaded that these were the people whom they were seeking. But what they did at that point was take them into custody and transport them back to the apartment of Shannon Bailey, and they detained them while they carried out the search warrant. And this case has the potential for being one more in an unfortunately perhaps lengthening series of cases in which the Supreme Court of the United States lessens the impact of the Fourth Amendment as a protection of individual liberty. One of the techniques, the philosophical techniques that the court uses to diminish the importance of the guarantees of privacy in the Fourth Amendment is to say that the cops can do something that is incident to something else that they do. For example, if you make an arrest as an incident of that arrest, you can look around the immediate area where the person is. In this case, the cops thought, well, incident to having the search warrant, we can engage in a detention. We can go after these guys, we can arrest them. We have no basis for arresting them as such, but we do have a search warrant. And so, incident to this search warrant, we will hold them in custody while we carry out the search. And perhaps inevitably the search did turn up criminal evidence. And they were prosecuted, and Shannon Bailey is now serving a 30-year prison term for his violations. The case really turns upon whether the court will expand an opinion that they wrote in 1981 in the case of Michigan versus Summers. Michigan versus Summers involved a ruling by the court that if an individual is in his own home at the time that you carry out a search warrant, you can detain them there while you do so. That was an incident to kind of result. And the Supreme Court said that was okay. Here, quite distinctly different, is that the cops did not detain them inside their home. They went after them arrested them. I think it was, Kannon was a mile or so away.
About a mile away.
About a mile away from the apartment, arrested them and brought them back to the apartment while they executed the search. So the question that is before the court is the authority to conduct a search, a judicially approved search, is that a sufficient basis for a warrantless detention? There was no judicially authorized power in the police to detain these people, so they're piggybacking that on the right to conduct the search. Now, Kannon Shanmugam is Kannon's client. Do you want to say something about that before I move on to other cases?
No, I think that's an admirable summary.
Okay. The other two.
I should just say one other thing. The Supreme Court is basically holding Fourth Amendment week, so that I'm actually going to be arguing this case the day before the two dog cases, which are being argued on Halloween. So maybe that way you will.
I want to, in the brief time that I have remaining, I want to mention two other cases. These are not in your book. They are cases of, I'm going to read to you all of what's here. Tibbles against Carter and Ryan versus Gonzalez. How many people in the audience were alive and functioning in 1966? Okay, good. So I was, at that time, in 1966, I was in my 8th year of covering the Supreme Court of the United States. And we had an interesting little case called Reese versus Payton. Payton was a man accused of murder, convicted of murder, but he was insane. Because he was insane, but at least it became insane by the time it got to the Supreme Court. The Supreme Court didn't know what to do with this case because it was understood that they couldn't execute him.
It was Reese.
Was Reese? Okay, I've got them backwards. He's from Virginia. Payton was the police officer. Yeah. But it was Reese. Thanks, Jack, for that. Jack was around then, too. Jack is a lot older than I am. Jack was my mentor. Jack was my mentor. As a matter of fact, let me digress again. Jack was then covering for the Washington Post, and I arrived after Jack had. I was representing the Washington Star. And typically for us in the press crew, when somebody new arrives, Jack approached me and I said, I'm Lyle Denniston from the Washington Star. And Jack said, why is it that the Star always sends a boy to do a man's job?
I don't remember that.
No, of course. Reese against Payton, the court did not know what to do with it because this man could not be disposed of. So they created a docket, a suspended docket, and Reese remained on that docket, I think, for 20 years, and finally had the good sense to die. Spared the court from having to deal with it. Reese against Payton is now coming back to the court because the court has two cases in which the defendants, having been convicted in state court, proceeded in habeas, but they were deemed to be incompetent. And as you may well appreciate, state governments, state prosecutors do not like the idea of letting a habeas case just run on and on and on. So the state in both of these cases insisted that even though the man was incompetent, the federal district court should go ahead and process their case. There is a federal statute that guarantees a defendant in a capital case, a death penalty case, a right to a lawyer. So one of these cases asks the court to decide whether or not, in addition to a right to a lawyer in a capital case, does a person have a right to be competent before the federal habeas court can proceed. And so these are really important cases to the habeas bar. Because they will raise the question of whether or not a federal court can go ahead and decide a case where the defendant, the convicted individual, cannot participate in the processing of the habeas case. So those cases will be heard back to back. In a strange twist, the court is only going to hear each case for 40 minutes. And that's because of the council came in. The council, I think this is a warning to private counsel. Don't count on the SG doing what you expect them to do. Because the lawyers on both sides of this case decided that they would only ask the court for 40 minutes, so there would be allowed time for the SG to come in and take part. Well, the SG came in and said, yes, we want to take part. But when the manipulation went over to the clerk's office, instead of getting 60 minutes for each case, they only got 40 minutes for each case, in which the SG will have 10 minutes of time, and the other counsel will have to divide up the remainder. But those are very important cases, and I'm afraid maybe I rushed over them too quickly, but those are my assignment.
Thanks, Lyle. Then moving on to Kannon Shanmugam, who used to be with the Solicitor General's office, but has more recently developed an expertise in bodily fluids. Because the two cases that we'd like him to talk about both involve the police extracting something from someone's person. In one instance, it's blood, and in another instance, it is DNA.
People were really concerned that we're going to deviate into other bodily fluids, but thankfully we're going to talk just about DNA and blood. Lyle gave us a sort of brief foray into subjects other than the Fourth Amendment, but I'm going to come back to the Fourth Amendment. It is really remarkable that the Supreme Court already has 4 Fourth Amendment cases on its docket out of the 36 or 39 or however many cases the court has already taken. And there's at least some possibility that the court will have a 5th on its docket, and it never ceases to amaze me that the court finds new, unresolved Fourth Amendment questions to address. Sometimes they involve the sort of question that you would have thought the Supreme Court would have resolved long ago. Sometimes these cases involve the application of the Fourth Amendment to new technologies, and I have one case in each category. The first case I'm going to talk about is a case in which the Supreme Court ran a review just this past week, a case called Missouri versus McNeely. And this case involves the question of whether exigent circumstances can justify the police's taking of a blood sample for purposes of determining and perhaps confirming whether someone was driving under the influence. So in this case, an individual was pulled over by a Missouri State Highway patrolman for exceeding the speed limit. The patrolman detected all the usual signs of intoxication, and he decided that in order to perhaps confirm that suspicion, he was going to actually take this individual to a nearby hospital in order to obtain a blood sample for purposes of verifying just how intoxicated he is. And before he did that, he actually asked the guy whether he was willing to give to submit to a breathalyzer, and he said no. And at that point, the patrolman decided to take a detour to the local hospital. They got to the local hospital. The police officer asked the guy whether he would consent to a blood test, and the guy said no. And I don't know about all of you, but I sort of feel as if whenever I read a brief, I often kind of reach a point in the brief where I just think, boy, there's one question I really have on my mind that isn't really answered. And when I was reading the cert petition in this case, I got to that point at page 3 when I read the following sentence. The patrolman then directed a hospital lab technician to draw a blood sample, which was collected as evidence at 2:33 a.m. So the petition doesn't actually tell us how the unconsenting individual had his blood drawn, and so we're left to imagine whether he was being held down while the lab technician took the sample, or whether the police officer just said, look over there, and then they just jabbed him in the arm. In any event, the blood sample was taken, and surprise, surprise, the individual's blood alcohol content was 0.15%, which is above the legal limit even in Missouri. And as a native of Kansas, I can slight the state of Missouri without fear of the consequences. So this case presents one of those sort of classic follow-on issues to an earlier Supreme Court case, the case of Schmerber, which many of you will have read or will eventually read in law school. And this is the case in which the Supreme Court permitted the taking of a blood sample in similar circumstances without a warrant. But the court, in its Fourth Amendment analysis, relied very heavily on what the court described as special facts that created the exigency. So in that case, the police officer said, look, we kind of have an exigency here because we need to investigate the accident further. We need to transport injured individuals to the hospital. And by the time we get all of that done, the blood alcohol level will have dissipated, and therefore we need to take the blood sample now. This case has no such additional facts, or at least the state is not making the argument that there are any additional facts. The state simply makes the argument that the exigency is created by the law of nature, that your blood alcohol level diminishes with every passing minute and hour from the point at which you're individually apprehended. And this is one of those issues that creates the sort of conflict in the lower courts. It is grist for the Supreme Court mill, and there was such a conflict here, and the Supreme Court granted review. There's not really been any merits briefing. There hasn't been any merits briefing yet because the court just granted review, but the Supreme Court will hear our argument, I suspect, in January. The other case I'm going to talk about is a case that we're involved in, and it's a case in which the Supreme Court hasn't yet granted review, and indeed a case in which we hope the Supreme Court won't grant review. But it is a case that presents a conceivably substantial and interesting Fourth Amendment issue, and that's the case of Maryland versus King. This case involves the question of whether the government can collect DNA and test the DNA of an individual who has been arrested but not yet convicted of a violent crime consistent with the Fourth Amendment. So in this case, our client, an individual by the name of Alonzo King, was arrested for ordinary assault pursuant to a Maryland statute. The Maryland police collected his DNA and then prepared a DNA profile and compared it against the national database and found a hit involving an unsolved rape. And the state sought to use the evidence that it obtained as a result of its invocation of the statute in a subsequent prosecution for rape. In this case, the Maryland Court of Appeals held that there was a Fourth Amendment violation with regard to how that statute was applied as against our client. And so critically, for purposes of the Fourth Amendment analysis, or potentially critically, there was no argument in this case that the DNA sample was being used for the purpose of investigating the immediate crime, that is to say, the assault for which he was arrested. Instead, the Maryland Court of Appeals, instead in this case, the sample was being used to investigate other crimes, and the Maryland Court of Appeals really critically relied on that distinction in its reasoning. While the state of Maryland has filed a petition for review in the Supreme Court, and even before it did so, it applied to the Chief Justice, who is the Circuit Justice for the Fourth Circuit, which includes Maryland, for a stay of the Maryland Court of Appeals decision. And I should note, by the way, for those of you who may not spend a lot of time in Maryland, that the Maryland Court of Appeals is in fact the state Supreme Court. They just call it the Court of Appeals. They also wear red robes, so they do things a little bit differently in Maryland. It's one of those M states, I guess. But in any event, the Chief Justice issued a stay of a decision of the Maryland Court of Appeals, which indicates that at least the Chief Justice has the view that there's a reasonable probability that the court will grant review and indeed reverse the decision of the court below. There is relatively little case law on this issue in the lower courts. The state essentially asserts a conflict that involves two decisions of state Supreme Courts and one decision of a federal court of appeals. There's actually another federal court of appeals case currently pending en banc in the Ninth Circuit, and in fact oral arguments were just held in the last week or so in that case. So I certainly think, and I'm sure we will be arguing in response to the state's petition, that this is one of those situations in which further percolation in the lower courts is warranted. But at least one member of the court seems to disagree with that assessment, and so there certainly is at least some reasonable possibility that the Supreme Court will grant review. If the court does grant review, I do think that this case presents a number of interesting Fourth Amendment issues, and I would actually refer anyone who's interested in this case to a post that Lyle did on SCOTUS blog immediately after the Maryland Court of Appeals decision, which I think really did do a cogent job of laying out the various sort of wrinkles to this issue as a doctrinal matter. I would just sort of highlight a couple of the potential issues that will come up in the event that the court grants review. The first is kind of the question of whether there are Fourth Amendment implications for the collection of DNA more generally. In this case, the police actually took a swab, a so-called buccal swab from the cheek of my client, and everyone seems to agree that that is a seizure for Fourth Amendment purposes. But of course, we all leave our DNA everywhere, and so there's kind of an interesting question of whether the Williamsburg police could come in this room after we all leave and just go around kind of collecting our DNA from the chairs in which we're currently sitting. And while the Supreme Court has traditionally suggested that the concept of abandonment would lead to the conclusion that there's no expectation of privacy in something that one leaves behind, one might query whether the analysis should be somewhat different in the context of DNA, where abandonment is sort of inevitable. The second question that the Supreme Court may have to deal with is the question of whether the Fourth Amendment analysis operates differently, where one is talking about arrestees. The Supreme Court has suggested that individuals who are convicted of an offense kind of leave their Fourth Amendment rights at the prison door, but there is some degree of uncertainty in the Supreme Court case law as to kind of where arrestees fall on the Fourth Amendment spectrum. And then third of all, there's kind of this question of how analogous DNA collection is to fingerprinting. Not surprisingly, the state makes the argument that the two are of a piece with each other. The Supreme Court's really never definitively opined on the proper mode of Fourth Amendment analysis for fingerprinting, which will come as a bit of a surprise given what a conventional law enforcement practice it is. But of course, DNA is a much more significant tool in terms of the amount of information that is conveyed. And as those of you who have been reading the newspaper recently will know, DNA contains a wealth of information, not just information about our own personal medical histories, but information that scientists are learning more about almost with every passing week. There was an article that you may have seen in a number of the leading newspapers about so-called junk DNA, DNA that scientists had previously thought was kind of irrelevant and contained no useful information, and about how, in fact, even those strands of DNA contain significant information. And again, not just information about individuals' medical histories, but information about individuals' potential propensity to commit criminal offenses, and information that can actually be used to link other individuals in the same family potentially to prior criminal activity. And at least in California, law enforcement has increasingly aggressively been using DNA testing for precisely that purpose, and they have solved at least a few crimes by linking those unsolved crimes to the family members of the individual who's being tested. So there's really a lot going on potentially on the merits in this litigation. Of course, again, we'll be trying to keep it out of the court, but in the event that the court grants review, I do think that this will be a very interesting case both for its practical implications and for its doctrinal ones.
Thanks, Ken. The Supreme Court has not yet taken a case involving tasers in the way that we are going to be exploring them right now, but it certainly has been on the mind of judges and lawyers. For instance, in a dissenting opinion in one of the recent taser cases, the judge imagined the great movie High Noon and how it might have turned out if Gary Cooper and the gang were armed with tasers instead of six guns. Might have been a more boring movie, but less lethal. Beth Brinkmann, who works at the Justice Department but is not involved in these taser cases, has done an exhaustive survey of this exciting, not that new technology. And you're going to update us on where the law is and what might intrigue the court in the future.
Sure, well, thank you very much, Jess. Yes, this is what the court didn't do this last spring. They denied cert in a case that was coming out of the Ninth Circuit en banc, which I'll explain in a moment. And perhaps the reason they denied it was because of the multitude of Fourth Amendment cases that my co-panelists here just described and discussed. The question here that's in this Ninth Circuit case is whether or not the use of a taser in particular circumstances constitutes excessive force in violation of the Fourth Amendment. And the circumstances are going to be very key here in just a moment. But let me just give you a little background about what tasers are, the little that I know from Googling and reading a couple of these cases. They are shaped like a gun, but there are two different types of uses for tasers. One is called the stun mode. And using Kannon as my mannequin here, you apply it to the person's skin directly and it jolts one we see more dramatically on TV called the dart mode. And that's as if I would shoot it down towards Lyle, and two prongs would stick into him, and actually he would then kind of be leashed to the stun, and an electric current would go through and stun him, and he would be incapacitated for the moment. And apparently there's no long-term effect from this. That's what they said. So those are the two different modes of tasers. The facts here are very interesting. This is a technology that's been around for a while, and it is one of these situations where it's a bit surprising that the Supreme Court may not have gotten to it yet. It's certainly not as new as DNA testing. And there are a lot of other lower courts that have looked through this. And by and large, a lot of the reasonableness determinations, perhaps not unsurprisingly, depends on the facts. The en banc Ninth Circuit case had two different facts that came up to them. The first one came out of Seattle, Washington, and these don't involve drugs or guns or any nefarious conduct like that, but this was a mother, Miss Malika Brooks, driving her 11-year-old to school. She's driving through a 35-mile-per-hour zone, and right in front of the school, if they're near the school, it gets down to 20. So she enters that zone, she's going 32. And gets pulled over by an officer with her 11-year-old still in the car. So the officer starts talking to her. She's allowed to let her son leave and go to school, which is across the street. One wonders how many children were watching this through the windows of the school. And the police continue and tell the Miss Brooks that she was speeding, and here's her citation, and that she has to sign it. She refused to sign it, saying, I'm not going to admit I did anything. The officer said it's not going to admit, it's just acknowledging receipt. He was right, but she disagreed with that. So they got into a argument, as best I can discern from the facts. And he said, well, if you don't sign it, I have to arrest you, and I'm going to take you down to jail, and I'm going to get my sergeant here. So the sergeant shows up, and they eventually approach her. She's in the car, and she won't get out of the car when they ask her to. And then he says, do you know what a taser is? He brings out his taser. And she says, I don't really know. And he starts describing it to her. And she said, I really have to go to the bathroom. I'm 7 months pregnant. And they have a little conversation about what they do about that. And apparently the allegation, he says, well, don't tase her stomach. And so one of the officers reaches in and twists her arm behind her back, and she's in the car. And then I guess takes the ignition keys out. So at that point, she couldn't drive off anymore because the keys were on the floor. And the officer then tases her thigh. Then within a minute, tases her twice more, one in her arm and one in her neck. And at this point, they drag her out of the car, put her face down on the street, handcuff her, and take her to jail. So she sued, claiming excessive force in violation of the Fourth Amendment. And I'll tell you about the other facts, and then I'll come back to say how the Ninth Circuit addresses. The other facts arise out of Hawaii, and it was a domestic dispute. Another mom and her 14-year-old daughter called the police, I believe unbeknownst to the parents. And by the time the police came, the argument wasn't going on anymore. The husband was outside with alcohol containers around him. And the police started to talk to him and wanted to make sure that the wife was okay. So the husband went to get her, and the police officer followed him in the house. So I think there's a little parallel here. The person's getting a little upset with what the police are doing. And the woman came back. They went outside and talked, and the woman ended up between the husband and the officer. And the officer wanted to go and talk to the man, and the officer either brushed by the woman or something happened, and she put up her arm, she said, to protect herself. He says, were you touching a police officer? And to make a long story short, there, without any warning, I should have told you, the first taser was the what's it called, the stun mode. This was the dart mode usage, and he stunned the woman without any notification or warning. So they sued also. The Ninth Circuit, it went through the district courts, and both of the cases came up to the Ninth Circuit together and were consolidated. And then the Ninth Circuit went in bank, so it was decided by 10 judges. And the judges, by a vote of 6-4 in Ms. Brooks's case, held that it violated the Fourth Amendment. And then in Giselle Mato's case, the mother in the other case, they voted by 6-2-2. 6 also said it violated the Fourth Amendment. In both instances, though, the court ruled that the officers could not be sued under Section 1983 of Federal Civil Rights Statute because of qualified immunity, which meant even though it's a violation of the Fourth Amendment at the time they did it, there wasn't a clearly established law that they were violating, so they were immune. Now, in Ms. Brooks's case, she still has an assault and battery claim, which is proceeding. That's not barred by immunity. And I don't know in Ms. Mata's case if she still has a matter proceeding against them. But the interesting thing is the officers in these cases petitioned for Supreme Court review because even though they won, they wanted to challenge the Fourth Amendment ruling. And in a case last term, I believe Justice Kagan wrote an opinion that said even if you won, you could petition for cert in that circumstance. In the one of the cases, I think it's a Seattle case, the city actually parted from the officers and said, no, you don't need to take this case. They're reading the case way too broadly. The test the Ninth Circuit had put out in this opinion, they said it's a violation of the Fourth Amendment to engage in that kind of tasering if it's not a serious crime, if the person does not pose an immediate threat to the officer, to others, and if they're not actively engaged in evading the officers or fleeing the scene. So that could be a pretty narrow ruling. I think that's what the city wants to interpret it as. In both cases, there were dissenting judges, and in Ms. Brooks's case, the mom in front of the school, four of the judges said it was an okay use, and Judge Kaczynski went on and just said this was the woman's fault. She got out of control. She overreacted. And you have to give the police a benefit of the doubt and realize how difficult their jobs are. Two of the judges said that also in Ms. Matos' case, but two also said that a trial was needed to determine whether or not there was a violation of a clearly established rule. The fact that they denied this might suggest that the Supreme Court thinks the lower courts are kind of getting it right, more or less. They had a real opportunity to decide both the merits of the Fourth Amendment issue and this immunity scenario, because not only did the officers petition, but then the women both cross-petitioned in the cases. So all of the issues that were up there, there were two cases, two different scenarios, two different methods of tasering, and yet they denied review. There are other cases out there, as I mentioned before. Interestingly, just a couple of weeks ago in Maryland, there was a case by the Maryland Court of Appeals on that involved tasers, and that wasn't a Fourth Amendment question about excessive force, but the question was if you taser someone and then the person tells you while they're on the ground that there's a gun in their pocket and you take the gun out, is that a arrest or a Terry stop for person to the Fourth Amendment if there isn't probable cause? And the court held that it was an arrest, there wasn't probable cause, so he could not be prosecuted for the gun. That was suppressed. The other thing I have to say is just on Wednesday there was an article in our local paper in Montgomery County talking about the use of tasers there. Two people apparently have died in the past 2 years out of hundreds and hundreds of uses. But there's a debate about whether or not, and this is the thing when you say non-lethal force, there's debate about whether it's really non-lethal force. Some folks have pointed this as an alternative to self-defense in your home instead of using firearms. On the other hand, there, in the law enforcement scenario, there have been instances where there are these allegations that it has caused death. The article in the Montgomery County paper was pretty interesting because it turns out that they're thinking of several of the deaths nationwide may have been due to actually the way in which people are handcuffed or restrained during arrest, and people with certain heart conditions, that may be the cause rather than the tasering. But these are classic Fourth Amendment reasonableness questions that I think the justices might be very interested in, but the fact that they have denied review also might suggest that they think the lower courts are getting it wrong. Now that there is, I'm getting it correct, now that there's this Ninth Circuit en banc case, it's going to be very difficult for officers to get immunity in the future, because you will now, as a plaintiff, be able to point to that as, an indication that there is clearly established law in these kinds of situations that it's excessive force. Again, I think if you're fleeing, if you're a serious threat to yourself or the officers or a bystander, it's a very serious offense, that may be a different outcome under that same analysis.
Now, earlier earlier this summer, I heard Erwin articulate a principle of jurisprudence for the Supreme Court when it comes to Fourth Amendment cases and other criminal procedure cases and police misconduct cases. And that was, if the justices can imagine themselves being subjected to the procedure, it's unconstitutional. And for illustration, he pointed to the two big Fourth Amendment cases in the last term, the GPS case, when the court was told that police could, with no reason whatever, attach GPS trackers to the justices' own cars, and the strip search case, which involved the unlikely event that a justice, after being arrested, would be unable to post bond, which went against the plaintiff or the arrestee in that situation. With that very sophisticated and nuanced theory, Erwin, how would you say some of these issues might turn out?
We're asking you to imagine the Supreme Court justice who is pulled over leaving his house as it's about to be searched, and it turns out that he's drunk, has his blood extracted, and then they conduct the DNA swab.
Lest this just seem totally cynical, it does explain the two results from last year. And also, if you think back to when the Supreme Court was dealing with cases involving random drug testing, every Supreme Court case to deal with random drug testing upheld the practice until the Supreme Court had before it a case coming out of Georgia, where Georgia law required that high-level government officials be subjected to random drug testing. That was declared unconstitutional. Now, of course, I could say, well, you know, the justices could imagine the police coming to their front door with a drug-sniffing dog, so maybe that's something that they would find a Fourth Amendment violation, but less likely that a drug-sniffing dog would detect drugs on their car, so that wouldn't be. I do want to say more seriously, though, the Jones case, just that you referred to, could have some implications with regard to the cases in this term. Because in Jones, Justice Scalia for the majority said, placing...
That's the GPS case.
That's right. And Justice Scalia for the majority said that a trespass is sufficient for a search. Now, in Katz versus United States in 1967, the Supreme Court seemed to reject that and say that everything was about a reasonable expectation of privacy. If a trespass is sufficient for a search, it has interesting implications for some of the cases we were talking about. For example, if the police officer comes with a drug-sniffing dog onto somebody's front porch, is that technically a trespass? Do we have an expectation? Is it a violation of privacy? Do we just expect that people can always come to our front door? Mail deliverers can come to our front door, post office at our front door, or is technically coming to the front door with that dog really a trespass within the meaning of Jones? Or I think of taking somebody's DNA without any reasonable suspicion. Isn't that the equivalent of a bodily trespass? And if the court is going to go down this path and say, trespass is sufficient for a search within the meaning of the Fourth Amendment, do you have that in these cases?
Now, do we have questions from the audience? Anything that's sparked your curiosity or observations?
I have a question. I can never pronounce your last name. What do you think? Why aren't people picking up what you just said about the Jones case? It seems to me that people are still stuck on privacy. They haven't found the strategy, the litigation strategy, really that's set forth in Jones.
They are picking up on it. And the place where it's being seen, for those of you who know the Fourth Amendment, are what are the so-called curtilage cases. This is the outside part of somebody's house, and there are a whole lot of cases where the Supreme Court said, if what the police are doing is going into the curtilage, that's not a search within the meaning of the Fourth Amendment, because you don't have a reasonable expectation of privacy with regard to the curtilage. But now courts are saying, and there's a recent Ninth Circuit opinion, in light of Justice Scalia's opinion in Jones, a trespass is sufficient for a search. So if the police come onto somebody's property, even on the curtilage, that's a search. I think that may be a real unintended consequence from Justice Scalia's perspective of the way he chose to write the Jones case, focusing on trespass and saying that a trespass is sufficient for a search.
Let me add one thing, just picking up on your question, Jess, about the members of the court kind of putting themselves in the position of the individuals in these Fourth Amendment cases. I think that there's a certain element of truth to that, and the first question of the oral argument in Jones to Michael Dreeben, the very experienced advocate for the government in criminal was, are you telling us that, you can attach a GPS tracking device to each of our cars without Fourth Amendment consequences? And Michael, to his credit, answered, yes, I am telling you that because we don't think that it's a search, which was the only intellectually faithful answer, but you could just sort of feel the air sort of coming out of the balloon as he said that. And for the next 29.5 minutes, it did seem as if the court had a pretty clear inclination of where they wanted to go. I think that there's a sort of countervailing consideration in these Fourth Amendment cases, which is that I do think that the court, and I think this is really, in some sense, perhaps traceable to the late Chief Justice Rehnquist, is very concerned about coming up with workable rules for law enforcement. And I think that that's true as a substantive matter. I think that's particularly true when you're talking about qualified immunity and the retroactive imposition of liability on law enforcement for things that they do often on the fly. But so I think as you're sort of thinking about arguing Fourth Amendment cases to this court, you're really thinking about workability. So in the Bailey case that Lyle talked about, we argue that the appropriate test should be whether or not the individual is in the immediate vicinity of the house, and if they're in the immediate vicinity of the house, we believe the Michigan versus Summers rule applies. And the government argues that, well, that's an amorphous standard, and we're arguing that that's a better standard than the government's standard. But a lot of the discussion sort of focuses on the question of which of these rules is actually practical for law enforcement when they're in the crucible of carrying out their very important and difficult duties. And I would just note that with regard to the McNeely case, the case on blood testing of individuals who are suspected of DUI, those sorts of workability concerns, I think, are going to drive the decision. The question for the court is going to be, given the preference for warrants, is it really practical to require the police to go get warrants when they're, investigating DUIs often in the wee hours of the night on weekends? And it'd be very interesting to kind of see how the briefing unfolds to see, to what extent that briefing is really driven by that practical consideration.
I think giving that guidance too is another point that is important to see how you develop the law in this area, because in qualified immunity cases like this, the Ninth Circuit in Bank did not actually have to decide the question of the violation of the Fourth Amendment here. The Supreme Court has held that when you have this kind of case, the Ninth Circuit could have just said, assuming it was a violation of the Constitution, we're going to say that there's qualified immunity for these officers because it wasn't clearly established at the time this conduct happened. But the Ninth Circuit expressly said, we are going to first decide whether there was a violation in this case because we want to give guidance going forward. If courts don't do that, there isn't such a robust body of law developed. Because when you think about the Fourth Amendment, there are two ways you litigate it, both indirect. You're arrested and you're prosecuted and you try and suppress the evidence. You're really raising it as a defense. Or you're arrested, generally you only sue, usually because they drop all the charges against you, which happened in these instances. Although Ms. Brooks was convicted for not signing the card, but the charges were dropped against her for resisting arrest at a trial. Actually, they did convict her, and there were against Ms. Matos, I don't even know what charges they tried to bring against her, and they dropped them because of that situation. And in those instances, you can, you might bring an action afterwards, but if it's not clearly established, there'll never be a ruling on the actual substance of the constitutional violation if the court chooses not to do so. So I think that is in tune with what Kannon was saying about judges being sensitive to the very difficult job that police officers and law enforcement officers have, and trying to give guidance. Like, we're talking about a case where there's no weapon involved, there's no serious offense involved, there's no flight even involved, and at least trying to draw a line there. And so I think it's a very good thing that the Ninth Circuit actually went ahead and decided that, because not all courts do.
And so Kannon, for someone like you who's representing an arrestee, your job, you're trying to come up with an alternate rule for the police. You're trying to give the police, here's how you can carry out your job without doing what you did to my guy. Is that a big thrust?
I think it's very important, and look, I've been on both sides of these issues because I was in the Justice Department. But even if I hadn't done that, I think you are trying to come up with a rule that makes sense given the countervailing interests. I mean, we all recognize that DNA is an important law enforcement tool. We all recognize that police officers, when executing search warrants, are incurring risks because it is an inherently dangerous environment. And the Fourth Amendment is, at some level, all about balancing. It's all about balancing privacy interests and law enforcement interests. And I think as an advocate, whichever side you're on, you have to be sensitive to that. And conversely, if you're representing the government, you have to be sensitive to the fact that the Fourth Amendment is all about protecting privacy interests. And where those interests exist, you have to acknowledge them.
I should mention another taser case in the Maryland Court of Appeals where there was the gun, it was a suppression motion. That was a split panel, that was 4-3. And, there were a very evenly balanced court arguing about the reasonableness of that. And I think that was a closer call.
That's the high noon case. All right, that's it. We are out of time. So please stay put. We will move on to our next panel in the next few minutes.